Hello, welcome to the February 2018 edition of TAXtalk. My name's Anita Monteith, and with me today we have Jane Berney, who is our business law manager.
Hello.
And Peter Bickley, who is our employment taxes manager and also looks after national insurance.
Hello.
Now we have two big topics today. The first one especially is extra big, which is why we've got Jane with us, and we're going to talk about GDPR, and then we're going to talk about the future of work, since Matthew Taylor has now not only published his report, but the government have responded, and we need to pick up a few of the proposals from that. But first we're going to talk about GDPR. Jane, you've been really busy on this subject. You keep telling me you've had 1,000 people watch your webinar. So come on, what is GDPR?
Well, GDPR stands for the General Data Protection Regulation, which is a piece of EY legislation to update the existing legislation, which in the UK is the Data Protection Act 1998. And because that legislation is 20 odd years out of date, it's been necessary because we've got to reflect the changing technology that we use, the changes in how we use data, and also it's to increase consumer protection. Because I'm sure you've heard lots of cases of scandals where data's been lost, and people are worried about how their data is being used, and so all of this is to protect consumers, and it's doing this by putting the onus squarely and fairly on organisations to hold personal data securely and appropriately.
Oh my goodness, okay, so we're talking about a bit of an admin burden there, but we'll come on to that in a moment. Actually, one of my children said to me last night, they're in their 20s, they actually asked me when the internet came along. They couldn't imagine that we'd ever had a time without the internet. And
well, that's why we need this new legislation.
I know, it's extraordinary, isn't it? Anyway, so when does the GDPR legislation come in?
It comes into effect on the 25th of May 2018, which is a date etched on my brain, and all in one go, because technically we're actually in the transition phase, and we have been in for the last 2 years. But this doesn't mean that everybody has to have everything absolutely perfectly in place by the 25th of May, but you've got to have made a step. And also, one of the things about the GDPR is very much an ongoing compliance issue. You've got to review and update and change things as necessary. So it's definitely an ongoing process, okay, rather than a YK2.
It's not big bang approach.
No, it's not.
It's not. At once.
No.
Okay. And who does it affect? Can you narrow that down at all? Or?
Everyone, actually.
Everyone. You can't narrow it down.
Well,
okay.
Anybody, any individual and organisation who processes the personal data of EU citizens.
Right, okay, personal data.
Well,
so is that all records? Is it manual records as well as
it's
electronic?
manual and digital. Manual if they're stored in what's called a relevant filing system, which means systematically. So I suppose if you were to throw your files on the floor, you could say it's not systematic, but I wouldn't recommend it. It still just applies to personal data and personal data of natural persons. Personal data is the same as under the existing legislation. In fact, many of the definitions like data processor, data controller, all those kinds of things are exactly the same. Right. It's just they've been extended and responsibilities changed. So personal data has been extended to reflect changes in technology. So it will now include online data, identifiers like IP addresses and location data, whereas before it's very much name, birth, address.
Okay, so it's a lot more texture to it than we used to have.
Yeah,
okay,
and that's just because of the changes in technology.
Right, so all of those people then with filing cabinets who think they're safe from GDPR, they are not, assuming there is some filing system attached. And do you think it is very different from what people do now?
No. In fact, the ICAEW, the Information Commissioner's Office, has said that if you are DPA 98 compliant, Data Protection Act,
Data Protection Act, okay,
you are 80% of the way. Because as I say, a lot of the definitions, the principles, the lawful basis for processing, all that kind of thing is the same, it's just adds on. And some of the changes are quite significant, and the fines are very different. Okay. But the basic principles, the basic approach, the basic ethos is pretty much the same.
Right, so it should just be a tidy up for a lot of people.
It should be, yes.
Okay.
It depends how complicated your IT systems are and how much data you've got. For some people, like people who do marketing companies, it's more problematic for them.
Right.
But for accountancy firms, not necessarily so.
Okay, well, of course, people watching this, they will be largely tax practitioners. Peter, how do you think that's going to affect our members, people in practice, for instance?
Well, I think, as I understand it, there are two types of data. There's firm data and client data.
Yeah.
So the firm data will be the data it holds about itself, and the client, like its own
So your
payroll.
members of staff?
Yes,
members
it'd be
staff,
employee
payroll,
records
that sort of thing.
and marketing databases,
Yeah.
the CRM or whatever.
And then the
Yeah.
client data will be stuff like where your client data about your clients, and if you're doing payroll for clients, again, data about those
It'd be
individual
their payroll
employees
data, yeah.
and stuff like
and
that, I
audit
guess.
and tax and whatever, it's that kind of stuff.
Right. So the old permanent file, if you still kept an old paper permanent file with information about the circumstances of your client, which you did for tax, didn't you, in case they need inheritance tax advice.
Exactly.
So all of that stuff would be included within it, I guess, now.
Well, I would guess, and especially as
I think it probably was anyway, because it's
yeah.
personal data. I mean,
Yeah.
it hasn't really changed in that sense.
And in fact, the original Data Protection Act, I don't think it didn't include computerised data, but I think that came in later, didn't it?
Yes,
So
there have been amendments, yeah.
yeah, so that's really why
So there could
the
be a catch-up for those people.
who might not have cottoned on that it's paper data is already in.
Okay. I can imagine that there have been people who've processed payrolls, perhaps their own, for a long time, who had built up workarounds. And I do remember going to a big hospital trust once that used to keep a nurse bank on a separate payroll. And what they would do is anybody who'd logged hours for that particular month, they'd run the payroll, pay those people, and it would just be blank pay slips for everybody else. Maybe with the advent of RTI, not so many people use that system, but you could still do that, couldn't you?
Well, if you put I mean, you could say that when they're not working for you, then they've left you, and then you've got to restart them, and then that is rather a hassle. Pardon me. So what you would do is you sort of tick the irregular payments box, and then you can sort of keep them on, and then the revenue won't be expecting an FPS, full payment submission, for that nurse or waiter or bar staff for that week or month or whatever. So I think, I mean, all those people, although they're not being used this week or this month or at the moment, you've still got data on them.
Yes.
So I think
and so the GDPR would affect, because it doesn't matter where the data is or how often you look at it. If it's personal data, it's personal data, and therefore you've got to comply.
So that actually might be a time to perhaps change your practice,
Yes.
have a bit of a clean up,
Yes.
get rid of the data you don't need.
Well, exactly. I mean,
Yeah.
you said earlier that it's quite an administrative burden, but you can look at it as a positive thing.
Yeah.
Like, I mean, I've been talking to people saying they've saved £140,000 on storage just because they had so much stuff they didn't actually need.
Yeah.
And this is a way of looking at what you're doing, seeing if that's the most efficient, why you hold it for so long, or do you need to hold it at all? You shouldn't be deleting everything willy-nilly, because you will still,
You might need it.
The GDPR says you should only hold data for as long as necessary. It just doesn't define what as long as necessary is. But if you're doing audit or for tax reasons, you have to keep it for a certain period, and that will trump the GDPR.
So how are you going to demonstrate compliance with all of this?
Well, this is one of the big differences with the GDPR, is that it has this accountability principle, which means that you have to demonstrate compliance. You can't just say, oh yeah, we do this, tick, tick, tick. You actually have to demonstrate, and the easiest way to do that is document it. So that's why we're saying to people you should be drafting policies and procedures as to what you do with what and why. And the ICAEW and the EU authorities have said, if you've made a decision about how long you hold data, then that's as long as necessary, provided it's reasonable,
Right.
and that kind of thing. But if you've documented it and explained why you're doing it, then that's the first step.
Okay, so I guess the very first step, even before that, would be to decide who's going to do it within your firm.
Yes, we are recommending that somebody should have, that you should appoint somebody very senior or to have oversight, because there may be some budgetary constraints, and also it filters all the way through the organisation. The GDPR actually talks about data protection officer, but that's only in certain circumstances, and most accountancy firms will not need somebody who's officially a data protection officer. what we're suggesting is perhaps have a data protection manager or a head of privacy or something like that. But the point is that somebody takes charge and has oversights and can review what's going on.
Yeah, and should probably be reporting at sort of board level.
Yes, definitely. Board level should be aware.
There's quite serious consequences of
the consequence, the fines and the sanctions. Because one of the sanctions is you could be stopped from processing, which is quite serious. And of course, there's the reputational damage as well.
So what do you do if it all goes wrong and you do have some sort of security breach or?
Well, one change for the GDPR is that data controllers and data processors now have to report breaches. But you don't have to report to the ICAEW every breach. It's only if you can prove there's been harm.
That's the Information Commissioner's Office.
Information Commissioner,
remind people.
Yeah, that's only if there's harm.
Okay.
You can prove that harm's been suffered as a result, and that means somebody could have, if you've lost a customer base and it's got people's names, date of birth and addresses, and that's all been lost, and that could lead to identity theft, so that's a real harm. But if somebody's just lost a list of telephone numbers, then that's not necessarily going to...
so bad.
Yeah. The thing is, you have to report it within 72 hours, and you have to be showing what you're doing. And now you can't... They will accept that you won't have necessarily solved it within 72 hours, but you should be reporting it within 72 hours and telling the ICAEW what you're going to be doing. Right. And even if you don't have to report it, you should be recording any breaches or suspected breaches and what you're doing. Because again, this is sort of approving your compliance, that you're aware of your responsibilities and you can do something about it, and you're taking it seriously.
Yeah, this is kind of making me
nervous.
Taking me back to audit days again. So you have your process, you write it down, somebody's responsible for it, and then somebody else should come along.
Maybe that's why I like it. Once an auditor, always an auditor.
And also, you kind of feel that there is a role for accountants in this.
Definitely.
I mean, it's what we're trained to do.
Yes,
we're quite good at checking and those sorts of things. Peter, we were talking about engagement letters. I know you look after tax engagement letters.
I do, yes.
And Jane looks after other aspects of them. But you're always talking about whether changes are needed. Do you think we need some change for this?
Well, I think we certainly do, yes. I think in the terms and conditions.
Yes.
And Jane has opted
Jane's
to
made
do
a
it.
plan.
Jane has a plan, so over to you.
You can't keep presenting people with new engagement letters, can you?
No, you can't. Well, I don't know.
You can.
You can, yes.
You can. I don't think they like
it.
it
Every year, but never mind. But if you look at the ICAEW's current templates, under terms and conditions, there's one bit that says data protection. That refers to the Data Protection Act 1998. Well, come the 25th of May 2018, you can't. It's the GDPR, and it will then be the new Data Protection Act 2018, which hopefully is coming in roughly the same time.
Right.
It's going through Parliament. So at the very least, your terms and conditions are going to have to change that. But also, we are working on wording, because the GDPR is a bit more explicit on what sort of things you should be telling people, their data subjects, what you're doing, who's got responsibility. It's all part of sort of the transparency idea that GDPR sort of invokes.
Right.
We are working on those, so for that. But what you can do, if you really want to issue an engagement letter now, it would have to say it's the DPA 1998, but you can say, but this is going to change, and that you will issue an addendum once the rules come in.
Right, and the advantage of doing that is that you don't have to go through that, please sign a copy and send it back to me business.
You can say, because you've already warned them and they've agreed to that,
Okay. I mean, a lot of people around about this time of year, obviously we've just had the self-assessment season of people who work in tax, will be sending out bills, and at the same time as sending out bill, you would consider what other paperwork you needed.
Yes.
So, for instance, you might be writing to them about what you're going to do with them for tax, and I'm sure you'll be making tax digital comments in there somewhere. But that would be perhaps an opportunity to refer to what you're going to do. If anything, you may just be informing them. But
yes. I think banks are starting to put it on the bottom of bank statements, and certainly if you get any information from an advertising people, they're starting to say the law is changing, you're going to have to opt in.
Right.
So you can do that, sort of say, this is what's going to happen if you want to, rather than waiting.
What happens if you do nothing?
Well, technically...
Be shot.
I mean, just because you've got the wrong act in your engagement letter,
technically that may, if you take a purely legal view, I suppose technically it could mean that it's invalid. Whether or not anybody would stick to that, I don't know, but technically, yes, it would be invalid.
Because you might
Are there
not...
any exemptions? Remember Someone who doesn't need
not really
to do.
There is one very small exemption about recording processing activities, but it's only if your processing is occasional. But if you look at the legislation, no processing would be occasional. I can't think of an example where it would be. No. The Article 29 working group, which is the EU body that's overseeing regulations and providing the guidance in bits, are actually looking at this, see if there can be any more exemptions for people who employ less than 250, but probably not, because it goes against the grain of the whole thing, really.
And 250 employees is actually quite a big business.
Well, exactly. As I say, it does seem to go against the grain of the whole thing anyway, so I wouldn't hold your breath.
No, okay, fine. So 3 things to take away from all of this. What would be your key?
The first one is not an IT problem or an IT issue. It involves everybody.
Right.
The second thing is you can't ignore it, and there's a lot of advice out there, but it's not complete as yet. The ICAEW and the Article 29 Working Group are still giving us a guidance. So it all seems quite daunting, but where you can start is actually looking at the data you've got, what you have, what you hold, what you do with it, who else holds it, like a cloud storage provider, and start mapping it, is what they call. The ICAEW have got a template for that, where you just list everything. And then once you know what you've got and what you do with it and why you've got it, then you can actually start making some decisions as to what are the consequences of this.
Right,
And that's the best way to start. And the third thing to do is just enhance your cyber security, your information security, because that's the best way to stop a breach and a fine. And that could be very simple things, just training staff to keep their laptops secure, always have a password, not to answer an email that they don't know who it's from and just click on a box. It could be very simple things like that, rather than sort of a wholesale review, but that will depend on your own particular situation.
Yeah, and actually, one that I remember reading recently, and I hadn't really thought about, because obviously working here, it tends to be done for us. But if you are working on a small standalone system, you may think, oh, well, I've got McAfee or one of those sorts of products. It's not enough just to buy it. You've then got to
keep it up to date.
Do your patches,
and
also, and run it, looking for malware. You actually have to actively do that, don't you, with some packages.
Yeah, so that's true.
No good just to spend that money. Well, the other big topic that we have at the moment is the future of work. And Peter and I have been involved in this. We kind of got involved in it about October time last year, when Matthew Taylor was first asked to have a look at the future of work. And it wasn't just employment. There was even a tiny bit of tax, but not very much, was there, Peter?
Well, in Matthew's report there was, yes, but that's partly because
But he wasn't asked to look at it.
No, the terms of reference didn't have anything in it.
No, so you went to see him and said...
So we went to see him, and probably others did as well, and we sort of said we can't consider this, employment without looking at what's driving the way in which employment of workers or contractors are taken on. You need to look at national insurance. And because the driver there is that employers' national insurance at 13.8% is a big incentive to take people on as, or pretend they're self-employed, or perhaps employ them through companies or whatever. And to his great credit, Matthew Taylor did take the point on board, and in his report he suggested that one of the things that needs to be done is to sort of really align, or more closely align, the national insurance for self-employed with employees. Unfortunately, the government hasn't taken up that point, because it is a bit, you're going to have too many losers, and perhaps it's going to be a bit difficult to get it through Parliament, and also perhaps because in the manifesto the government or government elected promised not to put up national insurance.
Yeah, it was. I think the PR aspect of all of that was handled very badly. And ICAEW have written to the Chancellor and suggested that what we actually need is an informed debate about the amounts of tax paid by the employed and self-employed. Obviously, we have a very broad membership, so it isn't for us to dictate what those rates should be, but I do feel that there is very little written in the press. I guess a lot of people who write these articles in the press will be self-employed. But actually, unless we have a proper informed debate about the amounts of tax people pay and what you get in exchange for what you pay, then it's very, very difficult to have a proper conversation about how we should make change to those amounts. I think we will be picking that up again at every available opportunity, and I've noticed that the CIOT have actually gone one step further. I think they are talking about bringing the actual rates together. But we've now had a response published by the government, and there is quite a lot in that, isn't there, Peter? You've been reading it, I know.
Yes, it looks...
What are the key points would you like to bring out?
Key points, well, in very small print. When you print it out, it looks like it's only that big, but in fact it's printed that way.
I think there are something like 60 or 70 recommendations in there, aren't
I think there are about sort of 50 odd. Well, the recommendations from the Taylor Review and also the recommendations from the Bayes Select Committee Review. So it actually brings it all together, which is really quite, someone's done a lot of work on this. Sorry. Someone's done a lot of work on this, so it's good. The consultations don't cover all the recommendations. They cover sort of 4 angles, well, 4 sort of sets of recommendations. There's a consultation on employment status, which is really asking whether the various different statuses of employee, worker and self-employed, whether they should be codified in law, and perhaps the worker or the dependent contractor, as I think Matthew Taylor
we are going ahead with that. We're going to rename workers dependent contractors.
Well, I think that's
the intention.
That's up for consultation, really. Okay. But I think that's the way it will go, as opposed to Lim B individuals.
Sounds terrible.
Lim B individual.
Well, I think that's out of section 230, subsection something rather, subsection B is where it defines what workers are.
Right, dependent contractors easier to manage than that.
It is a bit, isn't it? So that's the first one. The second one. Well, the thing is, they want...
So bringing the definitions more in line with employment law, tax and employment law?
Well, that's also one of the questions in there. Should they be slightly better aligned?
Right.
Also, should they be codified in law rather than in case law? Because at the moment, it's all case law. It's very fact dependent. Self-employed isn't really, defined at all. But if the other two are, then you've got to have a mop-up, I suppose, which is presumably self-employment, should the default be the other way. So all those...
that's actually quite an interesting one, isn't it, to make the default employee.
Well, that's just another thing. I'm not quite sure whether it's in the conduct, but it's just a sort of...
I have read that somewhere, actually.
Yeah, so it could be. So that's one of them. Then the 2 others, one on agency workers and one on transparency generally. One transparency for workers and employees, and the agency workers one is more for agency workers. That's things like, should get pay slips and what should be in the pay slips, and written statements of what your employment is and who the employer is and where you work and the hours you work.
Okay, well can we just look at the definitional changes aspect? I thought it was quite interesting that they are proposing to put more emphasis on control than personal service.
Yes.
Do you have any initial thoughts on that, either of you?
Well, I thought that was interesting as well. I suppose...
Because there was substitution, wasn't there? Yeah. People always used to
you
play
put
with
in
that.
A substitution clause, even if, and that was, will the substitute really be a true substitute? Is there a substitute there at all?
Would the engager accept the substitute?
I mean, if I want you to do the job because you're the, the IT expert or whatever, do I really want, Jane or anyone else?
Probably yes, actually.
I'm sure Jane would be just as good at it, so that would be fine.
This is the Deliveroo case, isn't it, where they were talking about substitution?
Yes,
On that.
But I think it's quite interesting, looking at control as a bigger issue than...
Well, I suppose control is more that's more the master-servant relationship, isn't it?
So it pushes you down the employment line.
Yeah. So personal service is more, can you do the job or can you do the job? And control is probably more like, in a way, what it should be. I mean, it's the Ministry of, whatever the case was in 1968.
I can't remember.
But it was the sort of case that I think was very much, that's one meant to be the leading case in this area. Ministry of Health, I think it was.
Presumably you'd like feedback, because we've only just seen this in the last couple of days, and we're going to be having a couple of round tables with specialists in the field. But what we really would like is your thoughts. How will this affect your clients? How will this affect your own engagements? The boundary between employed and self-employed, I think, is going to be the gift that keeps giving, both to tax and employment law for some time. You picked up as well on this proposal to give dependent contractors more information. I know that at the moment employees have a right, don't they, to get within the first couple of months of a new job, you can get a simple statement. You can ask for a simple statement about your hours of work and conditions and all the rest of it. And there's a proposal to give dependent contractors the same rights to ask for that. How's that actually going to work?
Well, of course, the practicalities of all these things are quite. It all sounds a jolly good idea, and I think it is a good idea. But it's just the practicalities of it. I mean, maybe an example is hours of work on pay slips, which is obviously needed if HMRC can properly enforce national minimum wage, and also so that a worker, an employee, can see that he's actually being paid the right amount for what he's meant to do. But that's not coming in. The regs have been laid. It's not coming in until next April of 19.
So hours on pay slips, that's something that's definitely coming in, regardless of the Good Work report.
That's right. I mean, it is one of the points in the consultations, but it's actually, the regs have actually already been laid. But I think it applies to everybody. So it applies to salary men like you and I. And it'll actually be quite interesting for quite a lot of employment's not quite so interesting for us, because I suppose as sort of higher up people, we probably just get paid the same amount each week.
When you write down I do 152 hours a week rather than
it's still only
35.
But it is
quite good that people will be told their rights, because how do you know you're being paid the right unless you know what you're entitled to? And actually this goes back to the GDPR, because that's giving individuals enhanced rights. But if you don't know what your rights are, you can't do it. You can't enforce them. And so one of the things GDPR talks about, and I talk about transparency, is you've got to tell people their rights. And so this is all fitting in with that thing, that same thing. Gender pay gap reporting is a similar sort of thing. If you don't know there's a gender pay gap, how can you protest about it or get rid of it? Modern slavery, again, it all seems to be going this way, that people need to know, and then they can make informed decisions. Yeah,
and you've been doing quite a lot of work on that, haven't you, recently?
Both of them, that's another thing I do. When I'm not talking about data protection.
Well, we'll have to come back and have another tax talk about those things. We're almost out of time, but just a few of the other things that we've been working on here at the Tax Faculty. We've been adding things to the Institute's Brexit hub. ICAEW.com, if you haven't looked at it recently, has got hubs being developed for particular topical issues. You will have heard me talk about our Making Tax Digital hub, ICAEW.com/MTD. There is also one /Brexit, and there's also one /GDPR.
On its way.
On its way.
It's now called Cybersecurity Resource Centre, but we're getting a special one.
So there's a hub for everything. Other things we've been talking about rent-a-room relief, and there is a call for evidence out at the moment from the Treasury asking you whether you do rent out a room in your home or whether your clients rent out a room in their homes. Well, it's a few questions about the use of the £7,500 exemption and whether that particular relief is still achieving the intention that it was originally meant to do, which was to encourage people to rent out rooms in their homes, so we had more accommodation available for long-term rent in the UK. Of course, it is targeted at people who are doing Airbnb type lets, and also who let out expensive properties and push off for a couple of weeks during Wimbledon or Cheltenham Gold Cup. And it is, I think, having looked at the call for evidence, it seems that they feel that isn't really what it was intended for.
Well, I think actually that, I mean, there are people who stay away from home, you know, for long periods of time, and they take week digs by the week, or touring theatre companies do that. So I think if any solution they come up with, I think it would be a great shame if that was prevented.
Well, we have had a meeting already, of course, and we have said that it seems to us that what you don't want to do is add to the admin burden, and there was a suggestion that you might do day counting, but I think we've said that we don't see that is an easily used solution, so we wouldn't be for that. And there was a suggestion that maybe continuing occupation while you let out your property might be a way around it. But anyway, it's still a call for evidence, and if you would like to respond to that, then I'm sure the Treasury will be very pleased to hear from you. Lots else that we've been doing. Peter did a webinar yesterday with Kate Upcroft. We've actually just about run out of time, but that's now up, isn't it, for people to see, tax faculty members?
Well, I trust it is. I'm sure it is.
Employment issues for everyone.
Employment update from yesterday, I'm sure it's up there. We'll do a Q&A on the questions that we have.
Okay, so you do a tax guide with the outstanding questions.
Yeah.
Brilliant. And we have the next tax talk on the 14th of March, which is the day after the Chancellor's first spring statement, in which he said there won't be very much tax. Well, we'll see. And Tax Club, which is on the 26th of February. All younger members, well, that's up to the age of around 35, welcome to that. We've got Pete Miller, who's going to be talking about corporation tax losses. That's going to be here in the Business Centre at Moorgate Place. Starts at 6:30. Please register online if you'd like to come along. Meanwhile, thank you very much to both Peter and Jane for today's talk, and we hope you've enjoyed it.